This case was poisoned from the start. No evidence, no witnesses, except admitted liars. Only a racially charged atmosphere, which was fanned by the police and the prosecutors, who knew the truth and distorted it and subverted it and destroyed it to convict an innocent man.
Listen, y'all, we are back with another one, man, and everything could change in this Karmelo Anthony case after defense files a motion asking Judge Roach to recuse himself. And in that motion, the defense argues that there were serious problems with how this trial was handled, including the alleged violations of the Waller factors, and also claims that the prosecution's conduct affected Karmelo Anthony's decision not to testify. So we are going to go into all of this. We are going to break it down. Welcome to On Go, y'all. Welcome to On Go. Make sure everybody is hitting the poll. Make sure everybody is liking. Make sure everybody is subscribing to the channel. And make sure you hit the notification bells to make sure that you're on go, okay? So salute to everybody. Make sure we're doing that from the very beginning. Hopefully everybody's having a good day. We are going to get into the document, which is the recusal for Judge Roach to recuse himself, all right? We're going to get into that as well. We will be also getting down to the Waller factors. We will be breaking down these Waller factors. One, right, the overriding interest. The court must find an overriding interest that is likely to be prejudiced. And two, all right, narrowly tailored. The closure must be no broader than necessary to protect that interest. And three, to consider the alternatives, that the court must consider reasonable alternatives to closing said courtroom. And four, adequate findings. The court must make findings adequate to support the closure on the record. Keywords, repeat with me, on the record, okay? It must be on the record, all right? So we're going to get into that as well. So salute to everybody. Let me just put my other microphone on so you can hear me even clearer. We will be getting into that as well, right? Why he can get a new trial. We will be getting into as well. We're going to break down a few things for y'all today. So salute to everybody. Salute to everybody. Hopefully you hear me well. Somebody write in the chat that you can hear me very well. I just put my microphone on to see if you can get my audio a little bit more clear for you. Good day to everybody. Hopefully you are hearing me very well. I don't want to waste time checking the audio. So if somebody could put a 1 in the chat, then that would be very helpful. All right. Okay. Salute to y'all. Let's get into this document. Read. We are going to get into this. Let me just check my audio just in case, man. I've been live for years, man. And I've done full lives and was talking for 58 minutes. And that thing was not on no volume, all right? All right, cool. Y'all hear me clear throughout everything. Salute to that. Salute to that. Salute to that. All right, let's get right into the read. Okay. The defendant's verified motion to recuse. To the honorable judge of said court and to the presiding judge of the administrative judicial region comes now the defendant Karmelo Anthony, sincere Anthony, by and through the under-designed counsel and pursuant to the Texas rule of the Civil Procedure 18A and 18B, respectfully moves to recuse the Honorable Judge Roach from presiding over the post-trial proceedings in this case, including the defendant's motion for a new trial and brief in support and the defendant's objection to the closure of the proceedings and to any continued restriction of public access, and motion for evidentiary hearings to clarify the report for record, both filed contemporaneously herewith in support. Mr. Anthony shows the following, all right? We're going to get into this. Now, remember this. Let me just tell you this one thing before we go further. The judge has to recuse himself because when you file for a motion for a new trial, guess who it goes to? It goes to the judge. So what the hell? You think a judge that presided over a case is going to say, you know what, I'm just going to recuse myself because I don't think I did a good job or we didn't do a good job? No. So he needs to get up out of here so that another judge can come onto this case right now and then they can go about making all the judgments and all of the rulings. So that's just how it goes, all right? Make sure everybody's hitting the poll. Make sure everybody's liking, because I will be changing the poll question shortly. And I'm just trying to gauge where everybody's thinking. This is not an echo chamber. Everybody's free to have their own minds. You want Karmelo to be free. You want him to be locked up, whatever the case may be, okay? You can have your own opinion here. Hopefully, we all just be respectful to each other. And that doesn't mean that we got to get into a fight and all of these things because of that. But have your own opinion. I don't believe in echo chambers. I'm not trying to make nobody a believer. All we're trying to do is just get down to the facts. I'm actually on standby for the transcripts. You know what I mean? Because I spoke to the court reporters. So as soon as I get the transcripts, we will have more closure. And then maybe both sides' arguments, whether you for nay or you for yay, both sides' arguments will get strengthened when we all get the transcripts. So we can actually have some real truth behind what we're saying, especially if we weren't inside the court with everyone else. All right. So salute to that. Timeliness and procedural posture. A jury found Mr. Anthony guilty of M, and on June 9th, 2026, the court imposed a sentence in open court assessing 35 years of confinement. Contemporaneously with this motion to recuse, Mr. Anthony has filed defendant's motion for the new trial and brief in support, and the defendant's objection to the closure of the proceedings and to any continued restriction of public access, and motion for evidentiary hearing to clarify the record for the appeal. Those filings require fact-finding concerning the court access order, courtroom capacity, public seating, overflow access, record restrictions, and the court's post-trial public statements. A notice of appeal has been filed. The grounds for this motion to recuse arose after the trial, as set forth below. This court retains authority over the post-trial proceedings. A notice of appeal does not divest the trial court jurisdiction to conduct post-trial proceedings, including a hearing to settle and clarify the record and a timely motion for new trial. The authorities continues through the 75th day after sentencing and until the appellate record is filed in the Court of Appeals. Because the Honorable Judge Roach is the judge who would preside over the requested evidentiary hearing, you see what I said? He would be presiding over that. Even though he say he's going to retire, not right now, he's going to be the one presiding over that. That's why they need him to recuse himself and get on up out of here. You see what I'm saying? He needs to go. Okay. Like a yard sale on the judge. Flea market for the judge. Flea market. Anyway, right? Evidentiary hearing and rule on a timely motion for new trial. Recusal is properly sought right now. Not now, right now. So this motion is timely. A motion to recuse must ordinarily be filed at least 10 days before the hearing at issue, whereas here, the grounds for recusal arise after trial. The motion must be filed at earliest practicable time after the movant learns of them. The 10-day requirement is not absolute, where the movant could not have known of the ground until after the motion would already be untimely. The motion must also be verified and must state with particularity the grounds why the judge should not sit on the personal knowledge and setting forth facts that would be admissible in evidence. This motion satisfies each requirement. The undersigned counsel entered an appearance on this cause on June 23rd, 2026, and first became aware of the interview described herein on that date. This motion is filed at the earliest practicable time thereafter, before any hearing on the motion for the new trial has been set or held, and before any ruling on that motion, okay? So we're going to get into multiple reasons of why Karmelo Anthony needs a new trial. You see, I read the Mike Howard affidavit, which had some solid grounds in there that I feel that could be helping towards his appeal and could be helping towards him getting a new trial. But that's not the only factors. Some people are getting hung up on just the Mike Howard affidavit and saying that's the smoking gun, then they ain't gonna move. Appellate courts ain't gonna move off that. Appellate courts usually want to stand by their verdicts, and they usually want to stand by what the jury actually claimed the verdict was. You see what I'm saying? Which is true. A lot of times the appellate court does want to stand with that. But with Mike Howard's affidavit, as well as compounded with a lot of these factors, the Waller factors, which I'm going to go into, and other factors, which we're going to go into here in the recusal, now we're going to start to see a compounding factor of why he deserves a new trial. Okay, make sure everybody's hitting that like button. Everybody sharing this video if you could. Let's share the video. It brings more people into this live so that we could get to the facts. I'm not talking on my opinion, on my emotion. Purple rain. I'm not on no purple rains, bro. I'm giving you the facts. That's all. I'm not trying to sway you. Okay, cool. Grounds for recusal. After the jury returned its verdict and the court imposed a sentence on June the 9th, 2026, the Honorable Judge Roach, the presiding judge at the trial, granted a televised interview to the WFAA TV channel, and I could read that as well. I got the document of this, the transcript of this said interview. I can read it for you if you want me to. Concerning this case that aired on about June 11, 2026. In that interview, Judge Roach expressed personal opinions about the propriety and the correctness of the jury's verdict, the fairness of the trial, and the correctness of the judge's own rulings during that trial. Such conduct implicates the Texas Code of Judicial Conduct and the objective appearance standard under Rule 18B. Now, this case remains a pending or impending proceeding before the court at this time, and public statements expressing the judge's personal views on these matters would suggest to a reasonable person that the judge's probable decision on any motion for a new trial that may be filed, recusal, is therefore necessary. He's not going to want to because he think that everything was on the straight and narrows. You see what I'm saying? He think everything was on the straight and narrows. But another reason for getting a new trial, right, is that the judge actually blew himself up. He actually spoke too much. He actually did too much of them bubble yums bumping. You know what I'm saying? He did too much of that. Because he went on to say, you know, he after the trial was over, he thanked all of the other judges. Remember, this courtroom is a big courtroom. It's a big courtroom. It got other judges that's holding cases in there, right? So when he pulled the overflow rooms abruptly, never gave no reasons, which is breaking one of the Waller factors. He never gave a reason. The fourth Waller factor is you're supposed to put on the record why you did it, right? He never did this. But in him talking about the other judges and how they were so patient and everybody in the court and all of that, he actually blew up that he actually did it. One, which we know he did it. He's the judge. He did it. But he was trying to give a reason a little bit of why he did it in a way, but he didn't give the reason. And remember, your reason supposed to be on the record. So that's another reason of why Karmelo Anthony could possibly get a new trial. Cool, right? Among the problematic comments that the Judge Roach made during the WFAA TV interview are the following. Judge Roach endorsed the jury's guilty verdict. When asked by a reporter, did the jury get it right? The judge answered, yeah, they did. Why don't you stay impartial and unbiased? It's crazy. Explaining that the jurors were picked based upon the law and listened to the facts that happened here in this very courtroom, and added that whatever they say, they get it right. Listen to this line. These guys are smart, man. Look, picked based upon the law, because you remember everybody was saying that he had a jury that wasn't black. They didn't have black. There was actually 5 white men, 5 white women. There was how much Indian people? I think 5 Asian people, 2 Middle Eastern people, a woman and a man, and then 1 Hispanic woman or something like that. There's been so much things that I'm reading right now I done forgot. But look, yeah, so it wasn't no black people per se, but it was some whites and some alleged non-whites, because some people say they white too. You Arabian, you white. At least Arabians might tell you they ain't black, they more white. Who knows, bruh? Don't judge me for being a racist. Who they're not a racist. Look, so the Judge Roach defended the courtroom access and no streaming restrictions that the motion for a new trial challenges, calling the decision not to allow cameras on streaming an easy decision, asserting that the general public had access to the courtroom, stating that of the 70 seats in the courtroom, he held 200 requests by the media, and that the public had only 27 to 32 public seats that we rotated every day, maintaining that members of the public could have stood in line with everybody else to obtain one, and concluding that he had struck that balance pretty well. Actually, people was there waiting, being pushed back off the line. Nika Knight was there. People was running down on the line. It's in this transcript, in the court transcript that I read, the 193 pages. They said people were on the line. It was 7th in the line. Next thing you know, they was 35th, being knocked out the place to get in the seat. People were coming in, jumping the line. All type of things was happening. That's documented in these files. You don't have to hear from word of mouth hearsay. That's documented in the files. This happened to multiple people, and some of those things are the reasons that they putting in there too for the new trial and helping Karmelo's appeal. D. Judge Roach addressed the suggestions then circulating in social media that he had personal relationship with the family of the deceased, denying that he knew the Metcalf family, disputing the authenticity of the images said to show otherwise, which appeared to have been fabricated, and volunteering that he sympathized with the Metcalfs and what they've been through. I don't know about the images. You know what I'm saying? I didn't jump on that gun to say, yo, these images was real. I thought they possibly was fake. Not to say it's not hard to believe that anybody could know anybody in these little small towns. And when you're from a place like in them little counties, could be very possible. And, you know what I mean? They lost the son. I also sympathize with the Metcalfs as well. Even if the pop's racist, even if we're hearing that the sons was doing racist graffiti, yeah, the twins, racist graffiti, yeah, and they didn't go into their alleged racist backgrounds, I still sympathize with them, because just because people being racist, that don't mean I have to be racist. And I'm not a racist person, bro. I think that good people don't have a color, just like bad people don't have a color as well. All right. E. Judge Roach addressed his rulings during the jury selection when asked about the defense's objection to the dismissal of the 3 prospective jurors who had identified as African American. Judge Roach stated that he followed the law in that case. Didn't I tell you about to the law? Listen, these people are smart. And did it to the T. And he was proud of that. And although he knew in the back of his mind what the perception was going to be, he was not here to satisfy the perception. Judge Roach reiterated that this public defense of his own ruling in a written statement to Fox News, which he stated, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and the jury. Now that the trial is over, it is important for me to provide transparencies. Listen, have y'all hit the likes? Because I'm about to hit this button. I've been working on a railroad in McKinney, Texas. It was a railroad in McKinney, Texas. Y'all can leave me be. Y'all had my boy Karmelo sounding like this to this man.
When there's this case called in.
Check, I can't do no life in prison.
The jury has to identify the defendant.
If you was on that jury, what would it take to convince you to set me free? That's how you save my ass.
That's how you save his ass, Mike Howard. You know, for next time, if you even maintain your damn license to practice law. Yes, there's barred for that thing. Anyway, let's get back to the documentations. Look, 6. A verified transcript of the interview is attached as Exhibit A. The recording of the interview is filed conventionally with the clerk as Exhibit C. And Judge Roach's written statement to Fox News is attached as Exhibit D. I have all the exhibits. We're going to be breaking them all down. Make sure you subscribe to On Go. I'm going through everything piece by piece. I may be doing videos on these things because everything can be done live, okay? So make sure you go into my video section, dropping likes, supporting the channel, doing the right thing by me, okay? Because I'm doing the right thing by you. Throughout the trial proceedings, an order prohibiting extrajudicial statements, the gag order, entered on July 28, 2025, barred every other participant in this case, all parties and their attorneys, witnesses, experts, consultants, agents and spokesmen, and law enforcement personnel, courthouse and court staff, and court-appointed officials from making any extrajudicial statements that address the character, credibility, expected testimony, guilt, or innocence of any party or witness, that discuss the anticipated evidence, or that is intended or likely to influence the public opinion. The court grounded that restriction in its own findings that extrajudicial publicity posed a risk of imminent irreparable harm to the right to a fair trial. By its terms, the gag order governed the proceeding through the conclusion of the trial. The court interview followed sentencing, and Mr. Anthony does not assert that it breached the order. What matters is not any breach, but the principle that the court itself announced in entering the order. The public commentary on a pending criminal proceeding threatens the fairness of that proceeding. The gag order is attached as Exhibit B in the same document of the new motion. The same judge who imposed silence on the defense, the state, and all other participants on the express premise that the public commentary threatens a fair proceedings, thereafter spoke publicly about this case, endorsing the verdict he is being asked to set aside and defending the access ruling now challenged, all while retaining the authority to preside over the post-trial proceedings still before them. If you're standing by the ruling that you made on that, you standing by the jury, just stay unbiased, stay impartial, right? Look, you standing by the verdict. Yo, the jury, we got it right. You know what I mean? We got him up out of here. We gave him a little 35, you know what I mean? A little 35 cents. We gave that to him. You know what I mean? So if you moving like that, what you going to say if we get a post-trial proceeding? What you going to do, bro? You're going to be on the same type of timing, bro. That's why he should have stayed impartial, and he should have been unbiased, and then maybe it would have been more grounds for him to stay and not recuse himself. But I heard the judge ain't trying to go, y'all. I heard he like this on the door. Gotta take me kicking and screaming. I heard you gotta take him kicking and screaming, bro. Nasty work with him, bro. Nasty work. I'm telling you. So I heard allegedly. So I heard. In his contemporaneously filed objection and the motion for new trial, Mr. Anthony contends that the management of the courtroom security and capacity led to the denial of a public trial. Judge Roach's own public statements reflect substantial personal involvement in the logistics and the access decisions now at this time. In his post-trial WFAA meeting interview, Judge Roach stated that he had been prepping for this trial with county departments and the Collin County system, the sheriff's office, and others for about 8 months. In his June 17, 2026 public letter, which I have the letter, the Judge Roach described the involvement of multiple county agencies and offices in the trial's logistical administration. These facts reinforce why another judge should decide the post-trial motions based on documentary evidence, testimony from non-judicial witnesses, and a record made in open court, rather than requiring the respondent judge to evaluate the legal effect of his own, who's going to do that, disputed public explanations and access related to decisions. You know, the hardest thing for a woman or man, even though Michael Jackson sang this song about a man, you're a woman, you better take the same look. I'm talking to the man or the woman in the mirror. Oh, yeah. I'm asking you to recuse yourself. That's my remix, Mike. R.I.P. to the greatest. Look, the interview was not Judge Roach's last public word on his case, though. On June 17, 2026, after sentences, while the court retained authority to decide a timely motion for the new trial and the cause remained subject to direct appeal, the judge published a signed public letter about this prosecution on Collin County's official government website under the title "Thank You Letter from Judge Roach," addressed the members of Collin County family. Judge Roach speaks of the recent trial of the state of Texas versus Karmelo Anthony as a finished undertaking and closes by calling that service one of the great honors of my judicial career. That's a great honor, bro. It don't get no nastier than that, bro. It damn sure don't get no nastier than that. That was nasty work, Judge. For real, for real. All right, let's get back to the document. But I'll just show you real quick since y'all could see that. Look, boom, we show you. Look, let's get into that, man. Show you the document. Show you how it looks. Look, this is how it looks. Look, thank you letter from the judge. Look, big, broad letter he wrote to the people. You know what I'm saying? I'll do a little scan on it real quick just to show you how it went. See what I'm saying? There's a quick scan on it. We'll get back to the documentations, though. But this is the thank you letter, and this is what they are referring to in the said recusal motion that we're reading now. Okay, cool. Salute to everybody. Make sure y'all dropping likes on the way in. Make sure you're all voting on the poll. We read in litigations and court cases. It's real strenuous, type of reading and work. But so I try to make it a little humorous, a little funny, add some elements of entertainment for y'all too as well. So hopefully y'all appreciate that. If you don't, dislike the video. That's okay. Or get in the comments and say, "Oh, to stop playing so much. Y'all come my ass on trial next." So when your ass in trial, I'll be joking when I'm talking about your shit. Stop playing, bro. Be nice with me. Anyway. So look. Let's go into the judge and the website. Thank you letter from Judge Roach. Address the members of the Collin County recital. Okay, cool. Okay, cool. Let's take it from right here. One of the great honors of my judicial career. Now, Judge Roach further tells the public that those who worked on the case contributed to ensuring that the process was conducted fairly. The very question a motion for a new trial challenging the conduct of the trial would put before the court to decide. A judge who publicly memorializes the trial as concluded and publicly pronounces the process fair while still holding the authority to grant a new trial signals to a reasonable observer that he regards the matter as closed, which is a true thing, right? You would think so. That Judge Roach did so once more in a public forum, having used the gag order to restrict every other participant's public commentary throughout the trial, sharpens rather than softens the appearance that the court no longer sits as a neutral arbiter of the post-trial proceedings that remains before it. 3, the standard and the argument. A judge must recuse where his impartiality might reasonably be questioned. Told you should have stayed impartial. A judge must recuse in any proceedings in which the judge's impartiality might be reasonably questioned, or in which the judge has a personal bias or prejudice concerning the subject matter. These procedures apply in criminal cases. They go and cite in some cases. I'm on 12. The standard is objective. The question is not whether the judge is in fact biased, but whether a reasonable member of the public at large, knowing all the facts in the public domain concerning the judge's conduct, would harbor a reasonable doubt that the judge is impartial. Skip all the citing cases. Skip. Okay. Right here. Where the trial judges undisclosed ex parte communications that they have in the judge's room, right, in his own chambers. That's ex parte communications that they have in the judge's chambers with said legal. Sometimes it could be with other people, defendants, all types of stuff. Ex parte communications, right? Ex parte communications with the prosecutor compromise the appearance of impartiality. What y'all was talking about? Him and the prosecutor, him and Mr. Worski, who's the one who drafted that gentleman's agreement between fool-ass Mike Howard, like you ever seen a prosecution that's cool with a defendant ever in life. You know who they was, right? Friends. How many of us have them? Friends. Ones you can depend on. Yeah, Judge Roach, Worski. Yeah, they was friends. Anyway, applied here, reasonable observer aware that the presiding judge during the Rule 21 period in which a motion for a new trial could be filed and before his authority to rule on a timely motion expired, gave a public television interview endorsing the verdict and defending the challenge access rulings, and the very matters a timely motion for a new trial would ask him to set aside. He gave himself up. Would reasonably doubt that the judge could impartially decide that motion. The objection is not that the motion for the new trial challenges the court's rulings. Every such motion does. But it is that the court publicly vouched for the correctness of those specific rulings outside the courtroom before it was called upon to decide this motion. So he did this before they got this motion out. Because remember, right after the trial, they end up doing the appeal, filing the motions, doing everything that they had to do. So you going on interviews and you speaking about this, right? Instead of waiting until you decide on this matter first, get this matter situated, and then speak on it. So that's what they saying here. You just jumped the gun. We ain't even conclude these matters with the motions and everything that we trying to do here, and you're already going on Fox News like you Zsa Gabor. Just always want to be in the limelight. Always want to be in the limelight, bruh. Tell me. B, the court's extrajudicial public commentary on this case requires recusal. The basis for this motion is that the court's extrajudicial public statements about this case, not its ruling under Rule 18A, a judge's rulings may not be the sole basis for recusal, but the comment to the 2011 amendment makes this clear that the term rulings is not meant to encompass a judge's statements or remarks about a case. Bias or prejudice arising from an extrajudicial source is a common bias for recusal. An extrajudicial source is one yielding an opinion on the merits on some basis other than what the judge learned from his participation in the case. The question, however, is not whether the court learned the facts of the case from the source outside the proceeding. It is that the court made extrajudicial public statements that objectively appear to commit it to the verdict and the challenge access ruling while it still retained authority to decide a timely motion for a new trial attacking those very matters. The contrary limitation that a judge's in-case rulings, remarks, or actions will only rarely support recusal has no application here because the ground is not anything the court did in the courtroom, but what is said about the case outside of it. Where the principle that an extrajudicial source supports recusal has been applied to a judge's public commentary about a pending case, courts have required disqualifications as set out below. Most pointedly, the court publicly defended the very courtroom access restrictions that Mr. Anthony challenges as us having denied him a public trial. The subject of his contemporaneously filed request for an evidentiary hearing and motion for a new trial, the court has now publicly characterized the same restrictions as proper and asserted that the public had access to the courtroom. The court would thus be required to rule on a challenge to its own rulings after publicly committing in the media to those rulings' correctness. A reasonable member of the public aware of these facts would harbor far more than reasonable doubt that the court could impartially decide that challenge, nor was the court's public defense of its rulings limited to the access restrictions. The court also defended its rulings during jury selection, declaring that it followed the law and did it to a T, that a judge would take it to the media to vouch for the correctness of his own contested rulings, while review of those rulings remains to be sought. Is at the core of what the objective standards forbids. Those access rulings are not merely challenged. A public decision is of the very court that reviews this one has since held that a comparable space-based closure of jury selection imposed without Waller findings or consideration of reasonable alternatives violates the right to a public trial and requires a new trial. In the cases that they cite is Stricker versus the state. These are cases that you could look in, right? Also Lilly. They didn't cite Lilly again. Okay, I'm going to be going into those cases as well. Stricker versus the state. Okay, this is one of the cases that they've cited and showing reasons and grounds for why they are requesting a new trial. Okay, and again, these are the Waller factors that they are referring to when they're speaking about the Waller factors. Okay. When you're talking about closing courtrooms, no audio feeds, no live video feeds, all of these things that you're doing, right? You have to have reasons for them. That's one. But then if you see number 4 here, you must give a reason of why you're doing it, an adequate reason, and it must be on the record. You must give a reason for the closure, which the judge never did. Okay, he never did. He just did the letter and the response afterwards, thanking the court judges and everybody, saying, listen, I know I just did it abruptly. I never really gave y'all a reason of why I did it, which confirms that he never gave a reason. So he kind of let the lid out and blew himself up by even doing the conversation, writing the letter, and doing the interview. He blew himself up, actually. And it kind of shows his impartiality and his bias, right? His non-impartiality, actually. All right, boom. So that okay, cool. Okay, cool. That the court publicly vouched for the correctness of the rulings, now challenged under recent published public trial authority from this court of appeals, only sharpens the appearance that it has committed itself outside the courtroom to a position that it must now revisit. The court also publicly endorsed the correctness of the very verdict the motion for the new trial asked it to set aside, stating that the jury reached the right result and that Mr. Anthony committed a crime. Crazy. A judge who has publicly proclaimed the verdict correct cannot be expected to impartially decide a motion seeking to, which makes sense. The standard that governs judicial public comment confirms the appearance problem. The Code of Judicial Conduct provides that a judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a matter which suggests to a reasonable person the judge's probable decision on any particular case. Although that canon does not bar a judge from explaining court procedures for public information, canon truth, this was not a neutral procedural explanation. The court endorsed the verdict, stated that Mr. Anthony had committed a crime, declared the trial fair, and defended the very access restriction Mr. Anthony now challenges. That principle reflects the same concern that drives the recusal inquiry. That public confidence requires a judge not appear to have resolved outside the courtroom a matter still before him. Mr. Anthony does not contend that the court should be disciplined. The point is narrower. The court's public endorsement of the verdict and the defense of the challenge rulings on a matter that remained pending with the post-trial proceedings yet to be decided and the case subject to appeal is precisely the kind of comment a reasonable observer would understand to signal the court's view of the very question it must now decide. Recusal does not turn on labeling the court's conduct a breach of any rule. It turns on the objective appearance standard. Mr. Anthony does not rest on any rule violation. A violation of a canon of judicial conduct will not stand alone, support recusal absent of the requisite showing. The controlling question is the objective. Whether the court's extrajudicial public commentary would cause a reasonable matter of the public to doubt the court's impartiality. Under that standard, the court's public commentary is strong evidence on the appearance inquiry under Rule 18b(b)(1). The asymmetry lies at the heart of this motion. By written order, the court found that extrajudicial publicity posed a threat of imminent and irreparable harm to the fairness of this proceeding, and on that finding, it silenced everyone else with a stake in the case. They put the gag orders on everybody else. Yet he over here, blurp, 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 blurp. You know what I'm saying? It's just crazy, bro. It's just crazy. The parties and their counsels, the witnesses, and even law enforcement personnel, court staff, and the court-appointed officials who spoke for that court. Then, with every other participant bound to silence by the court's own command, the court alone stepped before the cameras and spoke at length. See what I'm saying? About the very case that it continues to adjudicate, endorsing the verdict and defending the challenged rulings. A judge who declares public comment on a case so dangerous that all others must be silenced. That's bars. That's bars, yo. That's bars, y'all. Hold up, y'all. I got to bring in the railroads. That's bars. That's a bar. That's a bar. Where we at? A judge who declares public comment on a case so dangerous, because this is the reasons for the closures. It's so dangerous. Some people are contending, there's minor witnesses. So these are reasons for closures. But okay, there's minor witnesses, right? So that's the reason why you should close the case, pull the overflow rooms, take away the live streams and the live feeds and the audio, right? But look what they said in the full document, his appellate team. They said, listen, in Texas law, it confirms that a juvenile that's facing adjudication, okay, facing confinement in court, it's live, it's televised and all that. A child, a young guy that's a minor in court, got overflow rooms, got all these things. So even those cases, it didn't have to be restricted. Yet you felt so right that you had to restrict the same access to this courtroom. Kind of don't stand. All right. Remains before him, right? No. Must be dangerous that it must be silenced. And who then reserves that commentary to himself while the case remains before him does not appear to a reasonable member of the public as a neutral arbiter the law requires. The asymmetry standing alone casts reasonable doubt on the court's impartiality in deciding the pending post-trial matters. Federal courts applying the analogous appearance standard have treated the judge's public comments on pending newsworthy litigation as a serious recusal problem and decisions construing that provisions are persuasive here. In United States versus Cooley, a judge presiding over the pending matters appeared on national television and expressed his resolve as to how they should be resolved. And the court held disqualification required because the appearance was that the judge had become an active participant in the case instead of a detached adjudicator. See what I'm saying? Yo, yeah, man, he committed a crime, though. You know what I'm saying? Yeah, man, we got it right. Yeah, they getting a little 35 years. He be all right. You know what I mean? You in here talking like you wanted the public, bro. You're not. You're a judge, bro. You're a judge. You're held to a certain standard as a judge, even above everyone in that court. Prosecutors, lawyers, everybody's there. You are above all these people here. You're a judge. Act like such. But everybody wants TV time. Everybody wants Zsa Zsa Gabor time. Nasty work. Let me plug my charger. Okay, adjudicator. In Reed Boston's Children's First, a judge gave a newspaper interview about a pending high-profile case, and the court ordered disqualifications, cautioning that judges must be particularly cautious about commenting on pending litigation in newsworthy cases. Those decisions describe this case, a judge who granted a television interview about one of the most closely watched prosecutions in the state, endorsing the verdict, pronouncing the fair trial, and defending the very access rulings under review, has assumed the posture of an advocate for his own judgment rather than a neutral arbiter of the motion that challenges them. C. The court publicly endorsed positions on issues that it still had authorities to decide. Mr. Anthony's conviction is now pending on direct appeal before the Court of Appeals for the 5th District of Texas Court at Dallas. The trial court retains lawful authority over a timely motion for new trial, notwithstanding the notice of appeal. The appearance problem is therefore not one of jurisdiction. Mr. Anthony gave notice of appeal on June 10th, 2026. That's the day right after his verdict. It was on the 9th. The next day, bam, they filed the appeal. They ain't playing no games with that. They ain't playing no games. Hey, it was dead to you. Straight. You ever had an ex hit you back like this? I'm coming for my TV. Yeah, I want the VCR too. You like VCR? I mean, I want the VCR. He ain't got nothing. He just mad. Look, I'm coming for the VCR too. You think he gonna leave me? Came right back. Yeah, that's how they responded, like your mad ex. Okay. With that appeal already initiated, and before any appellate briefing was filed or any reviewing judge had written a word, the court went on television and pronounced its own rulings correct and the verdict sound, reviewing and affirming its own decisions in the court of in public opinion, ahead of the very courts to whom that review belongs. A trial judge's public review of the merits of his own rulings while the court retains jurisdiction with the post-trial proceedings yet to be decided, the notice of appeal on file, no brief yet written, and no appellate judge has spoken, underscores why a reasonable observer would doubt that the court could now impartially preside over the post-trial proceedings. Including the timely motion for a new trial, a reasonable member of the public would regard a judge who publicly vouches for the correctness of his own judgments while those judgments await the considered review of a higher court as having exchanged the neutrality of the breach for advocacy of his own work, and would doubt that the same judge could impartially preside over the post-trial proceedings that remain before him. The need for recusal is brought to a point by the proceedings that now lie immediately ahead of Mr. Anthony has objected to the sealing of the court file and has asked the court to convene an evidentiary hearing to establish for the record and for the appeal how the trial was structured and closed, and how, when, and by what authority the court file and the reporter's record were sealed and withheld. Those are the inquiries into the court's own conduct. The judge who imposed the closure, directing the sealing, and then publicly defending both would be asked to preside over a hearing receiving evidence about the propriety of those very acts. And in the motion for the new trial to follow, to decide whether to require a new trial, a reasonable member of the public would doubt that the same judge could sit impartially as a fact finder on the lawfulness of his own challenge decision. That doubt itself reason to refer this matter so that a different judge conducts the hearing and decides the motions that depend on it. There is a further dimension to the court's public commentary. In taking its defense of its own rulings to the press, the court spoke not as a private citizen, but as with authority of judicial office, lending that authority to a one-sided public account of a case it must still decide. The effect is to convert a matter committed to orderly adjudication into a public contest, one in which Mr. Anthony must either answer the court in the media or allow the court's public endorsements of its own ruling to stand unrebutted. That makes sense. Since you done came out publicly and spoke about it, it would leave for him to come and speak on his own behalf, or his lawyers or whoever is his, you know what I mean? That makes sense. It forces own rulings to be rebutted while that same court continues to preside over the motion challenging them. A reasonable member of the public would not regard a judge so situated as the neutral arbiter the law requires. D. The court also took to the airwaves to answer a suggestion of its own partiality that no party had raised. What he said about that? Salute to y'all. Let me check on y'all, see what's going on there. Salute to everybody in the building, y'all. It's going down, y'all. It's crazy. Karmelo was like this.
Witness for the prosecution.
You my lawyer, ain't you?
Yeah.
Ask him.
Your Honor, one question.
Make up your mind, Mr. Brigant.
Mr. Howard had to be forced. You my lawyer, right? Go ask a damn question. We know why he couldn't ask no question, because the man that made a handshake deal, he done did a gentleman's agreement that wasn't so gentlemanly. And then he got the bad side of the deal, which left Karmelo with the bad side of the deal. And talked to Karmelo 10 minutes right before he had to decide the biggest decision of his life, which is he going to testify in his own case? I got to go break all of this down to my client. Some of that blame falls on the parents too, because you're supposed to see how they're going to run this case and why they're making deals. Did you know about the deal? Did the parents know about this deal that the defense attorney was making with the prosecution, Bill Worski? It's crazy, bro. All of y'all got to be a part of that, bro. I just can't hold that back, bro. I'm sorry. Mr. Anthony does not allege that the court had any relationship with the family of the deceased. The social media material suggesting such a relationship appears to have been fabricated, including by artificial means, AI. The point is not the truth of that suggestion, but the court's response to it. Rather than allow a non-record rumor to remain outside the proceedings, he should have just never answered it. The court used its televised interview to answer a suggestions of its own partiality that no party had raised. No one said this to him. It's just something that's happening on social media, and he fed into social media. Wow. Denying any relationship with the family, and in the same setting, volunteering that it sympathized with the Metcalfs and what they've been through. He's not a regular person. He's a judge. We understand. I told you, I sympathize with them too, son. Regardless if they racist or not, I don't care. They lost a son, bro. I got children, bro. Like, come the hell on, right? But you as a judge and as an arbiter of the law, bro, a neutral party, you already seeing that you're one-sided, and you said that Karmelo has committed a crime. So it goes to show you how you look. There's opticals just based on optics, whether he feels a way or not. It shows that he's biased. In stepping before the cameras to defend itself against extrajudicial allegations and to express sympathy for the family of the deceased, while the Rule 21 period remained open, post-trial relief was impending, and the court still retained authority to grant a new trial, the court assumed the posture of a participant answering a charge rather than a detached adjudicator. The governing question is objective: whether the court's conduct viewed by a reasonable member of the public conveyed an uncommon interest and degree of personal involvement in the case. Volunteering a television appearance to speak out about a pending high-profile matter unavoidably created the appearance that the judge had become an active participant rather than a detached adjudicator, such that a reasonable person would harbor a justified doubt as to his impartiality. The First Circuit Court ordered the disqualification on materially similar facts when a judge gave a press conference about a pending newsworthy case in Reed Boston's Children First. A judge who goes on television to deny a personal allegation and to express sympathy for one side's family, while the Rule 21 period remained open and the post-trial relief was impending, conveys the very personal involvement those decisions describe. This ground is of a piece with the closure it accompanies, the court's sealing of the record, and its restricting to the public and to the press access created the information vacuum in which such rumors could take hold. That's what I'm saying. All of those closures, right? Us not being able to see the case, watch it on TV, listen. This is why we getting to the point that people is online arguing. Did the Metcalf twins arrive first at the stadium? Did Karmelo arrive first at the stadium? This is something so basic, bro. You're supposed to all know this. There should be no discrepancies about this. One of them arrived at 9:54 a.m. One of them, this is facts I'm telling you now. One of them arrived at 9:56 a.m. They arrived 2 minutes within each other. That's a fact. Who arrived first? Who arrived second? That's what's in the air. 4 minutes later, after 9:56, is when the tug of war that happens, right? Austin is poked, right? 10:05, the responders are coming in. That's backed by even the 911 call. When Mason hangs up the phone call on the 911 call, said, my friend just got poked. And Austin just tried to make a move and all of that. He says, I can see the lights. Thank you for being so quick. He can see the responders coming. When that call ends, it says 10:05. So we know that for a fact, besides the statements that's in the court. 10:07, they're working on Austin, trying to help him. But remember, it was like too late for him. And 10:12, they're bringing out that blue tarp and they're preserving the evidence over the weapon. Grabbing a book bag, random book bag thrown on the tarp, coming to find out it's Karmelo Anthony's book bag. Out of all of the book bags that's left behind by the students that witnessed this tragedy, it was Karmelo Anthony's book bag. Cool. It says, it created the information vacuum in which such rumors could take hold. The court then used the press access it had reserved both to refute the rumor and to justify the access restrictions that produced it. The objective appearance is of a judge managing the public narrative of his own case from both directions. Standing alone, this thread is the most this thread is the most modest of the grounds stated above. And Mr. Anthony presents it not as an independent bias. Mr. Anthony presents it not as an independent basis for recusal, but as confirmation of the personal involvement and want of the detachment that the court's endorsement of the verdict, its defense of the challenge rulings, and its public review of its own judgments already established. Due process reinforces the need for an impartial decision maker. Makes sense. The court need not reach constitutional due process, Rule 18b(b)(1). Objective appearance standard is sufficient. Due process confirms the importance of an impartial decision maker and the principle that the recusal is required where the probability of actual bias is too high to be constitutionally tolerable. But the relief requested rests on the Texas recusal rules. At a minimum, the circumstances counsel strongly in favor of the referring this motion so that a different judge decides both recusal and the post-trial proceedings, including a timely motion for a new trial. Separately, and in the alternative, to the extent the motion for new trial requires fact-finding on the courtroom capacity, the volume of media requests, public seating, and its rotation, the feasibility of an audio feed, and the reasons reasonable alternatives were rejected, the court's own public statements reflect that it possesses personal knowledge of disputed evidentiary facts concerning the proceeding and independent circumstance that reinforces recusal. It's nasty work I have, bro. It's most definitely nasty work I have. Cool. Let's go on to this. We're also going to be breaking this down too as well. These are some of the cases that the defense has cited, right? So as you can see, in the top 4 cases, no overflow room. Did they have an overflow room? Did they have a live or remote feed available? And what was the outcome? And they show you the case, right? So you could see in the top 4 cases, Waller versus Georgia, they didn't have a overflow room. No to the overflow room. The entire suppressing hearing was closed and no alternative was offered. What was the outcome of that case? The closure was unjustified and a new suppression hearing was ordered. Okay. In the Stedman versus the state case, they didn't have an overflow room. The family was banned from voir dire, the jury selection process, for lack of room and no alternatives were considered. What was the outcome? Structural error, conviction reversed, and a new trial ordered. In Lilly versus the state, okay, no trial, it was a no. The trial conducted in a restricted access setting in this case, right, as far as live remote feeds and audio feeds. What was the outcome? Structural error, new trial ordered. In Presley versus Georgia, no overflow room, okay? But look, they had no overflow room. In this, I'm going to show you the difference. No overflow not considered, right? Reversed, trial must consider reasonable alternatives. Now, look, in these 2 cases, Williams and Zorns, in Williams versus the states, yes, they did. And they did have an overflow room and they had a live feed, but that was going to a neighboring courtroom. And it was a trivial closure, but it was no violation in that case. See what I'm saying? And in the Zorns versus Bowling case, they had an overflow room, but it was a remote viewing from an observation room. And it was a trivial closure, and there was no violation in that matter. But now in this case, Karmelo Anthony's case, they provided an overflow room during jury selection, during voir dire, right? And then it was withdrawn for the testimonial phases of the trial. And there was no feed after that. So they actually gave you one and then pulled it with no reason of why they even pulled it. So in that one, they said that this case falls on the Waller, the Stedman, and the Lilly side, the top 3 cases that you're looking in here. And in all of those top 3 cases, you see what the outcomes was. So based on that, plus this, plus Waller, plus a lot of factors, these are compounding reasons of why I believe that Karmelo Anthony has real good grounds for getting a new trial. You know what I'm saying? So it's not just because of emotion. Oh, he got railroaded. I've been working on the railroad. Choo-choo. Not just that, which I believe he got railroaded, but based on a lot of other compounding factors, right? Okay. Mr. Anthony's request that the Honorable Judge Roach, within 3 business days of the filings of this motion, either sign and file an order of recusal or sign and file an order referring this motion to the presiding judge of the First Administrative Judicial Region for assignment for the judge to hear and determine it. Because this motion is filed after evidence was offered at the trial, Mr. Anthony recognizes that Rule 18A F2B and not Rule 18A F2A governs so that the responding judge may proceed unless stayed. Mr. Anthony therefore further requests that the presiding judge of the First Administrative Judicial Region or the assigned judge immediately enter an interim order under Rule 18AG4, meaning that he'll be the step-in judge. He'll be the interim judge. The judge that steps in the middle and takes over is the interim judge. So he's telling this person they need someone to file this, you know what I mean, to be an interim judge. Staying any ruling on the motion for a new trial until this motion, hold off on any ruling on this. Staying it, meaning hold off on any ruling on this until this motion is determined, and set this motion for hearing as soon as practicable. So that a neutral judge may hear and rule on the motion for the new trial before the court's authority under Texas, you know what I mean, the appellate courts, whatever. Mr. Anthony seeks this expedited determinations, not to delay. He wants it expedited. He wants this as fast as possible, ASAP. But to permit a neutral judge to decide the motion for the new trial within the time the law allows. And I believe if he gets that neutral judge, he will get that. Because looking back, he's going to see the faults that the judge made. And just the judge even played himself by doing a live interview, by writing that letter, by doing all these other things. I think he played himself, bro. He played himself. Time is of the essence. This court's authority to rule on this motion for the new trial expires by operation of the law on the 75th day after sentencing, and that deadline continues to run during the referral and the reassignment. I wonder how much days we're in right now. It was June 9th. Somebody do that math. June 9th to now. How many days we in? Mr. Anthony therefore respectfully requests that the referral, assignment, and the determination of this motion proceeds on an expedited basis so that the judge to whom this motion is assigned may hear and rule on this motion for the new trial before it's overruled by operation of law. By separate cover, Mr. Anthony has requested expedited assignment from the presiding judge of the First Administrative Judicial Region. How many days is it from June 9th to today? That took too long. ChatGPT. It's been 31 days. Damn, bro. It's crazy. He's been in the building for 31 days. Yo, we only got you got to get up on the good for like 44 days, bro. Yeah, only 75 days. So they only got, look how quick that month flew by. They got to get on this now before that time expires. And whose fault is that going to be? Y'all fault or Karmelo's fault? When they filed their appeal the day after, the 10th, it was already in. Bang. They wasted no days. After the 9th, his thing was in. Bang. Wherefore premises consider. Mr. Anthony respectfully prays that this motion, prays that this motion be granted, that the Honorable Judge Roach sign an order recusing himself, or in the alternative, refer this motion to the Honorable Ray Wheelies. Let me see who this is. Who is the Honorable Judge? This has got to be in Texas, but who is the Honorable Judge Ray? His last name, Wheeless. He's the presiding first judge. No, he's the presiding judge of the First Administrative Judicial Region. Give me a little background on this guy. for assignment of an impartial judge to hear and determine this motion and Mr. Anthony's motion for new trial, and that Mr. Anthony has such other and further relief to which Mr. Anthony may justly be entitled. Okay, cool. Let's get into him. Okay, his current position, he has served as the presiding judge of the Texas's first administrative judicial region since March of 2018, after being appointed by Governor Greg Abbott, and was later reappointed. Previous judicial service, before taking that role, he was the judge of the 366th District Court in Collin County, Texas, where he handled a broad range of civil and criminal matters. His education, he has a Bachelor of Business Administration from California State University, San Bernardino, and a Juris Doctor from the University of Texas School of Law. His board certifications, he is one of the relatively few Texas attorney who is board certified in criminal law, in civil trial law, and personal injury law. So as a presiding judge of the First Administrative Judicial Region, he generally does not act as the trial judge in everyday cases. Instead, his administrative duties include assigning judges to cases when a judge is recused or disqualified or unavailable. So he's the one that assigns a judge. When he get recused, he'd be the one to assign a judge to Judge Roach's court. But they ain't saying assign nobody. They say, nah, we want you, bro. So they going for the big dog. You know what I mean? He's the guy that assigns judges to recuse. That's crazy. He's overseeing judicial administration for the 7 counties out there in the First Administrative Judicial Region: Collin, Dallas, Ellis, Fannin, Grayson, Kaufman, and Rockwall. So he's a big boy. So they ain't going for no little fish. They ain't going for Nemo. They ain't finding Nemo. They going for they going for Jaws of the judicials. Cool. Let me get past that. Cool. Verification. Let's see what this says. Before me, the under the sign authority on this day personally appeared Russell Wilson II, who by me duly sworn, deposed, and stated, my name is Russell Wilson II. I am over 18 years of age, of sound mind, and competent to make this verification. I am the attorney for Mr. Anthony. In this case, I have read the foregoing motion to recuse, that factual statements concerning my appearance in this cause and the timeliness of this motion are within my personal knowledge and are true and correct. The factual statements concerning the content of the Judge Roach's public statement, his WFAA TV interview, and his written statement to Fox News are based on authenticated by the recording of the interview filed conventionally with the clerk as Exhibit C, the declaration accompanying the verified transcripts attached as Exhibit A, and the written statement to Fox News attached as Exhibit D, each of which I have reviewed. The factual statements concerning Judge Roach's public letter of June 17, 2026 are based on and authenticated by the letter as published on the Collin County's official website. I just showed y'all that letter just now on this live, attached as Exhibit E, which I have reviewed, in the factual statements concerning the court's public description of its preparation for and coordination of this trial are based on and authenticated by the verified transcript attached as Exhibit A, and the public letter attached as Exhibit E, which I have reviewed. The ordering prohibiting extrajudicial statements is attached as Exhibit B. So this is one of the 6 new lawyers that Karmelo has. He has a 6-lawyer team now. He has a whole Avengers of lawyers now. And this specific lawyer, he's the appellate lawyer. He's a veteran appellate lawyer. You know, you have different kinds of lawyers. You need an appellate lawyer that's going to really know how those courts work and know the loopholes and know how to really get through these court systems. You know what I'm saying? So it's good for him to have a good veteran in Russell Wilson II, besides the other 5 lawyers that he has: Gary Bledsoe, Brooke Clues, I think his name is Steve Derriden, and a few others that he has as well. Certificate of service. I certify that a true and correct copy of the foregoing was served to Collin County criminal. Okay, yeah, that's him that did it. Yeah, he swore. That's cool. Index of exhibits. We just told you these are the exhibits. A is the transcript. Roach, custodian. Okay, cool. B, extrajudicial statements. That was the gag order. At one point, they were saying that you couldn't write nothing in the court, but they ended up lifting that. That's how tight he was. He was saying, don't write nothing in the court. Imagine if we only had to depend on the big news channels to give us our news, bro. You already know they told you, fear. Yo, they be telling lies to your vision. What you think television mean? Tell lies to your vision. Exactly. You know, a lot of stuff that come on the news, you can't even believe it, bro. You know what I mean? So you need people that's going to come outside and cover a case too, like the Neek at Nights, like the Queen Shebas, like these kinds of people that's going to be out there talking from their own lens. Because I've been around a lot of news people. I have a lot of new people that's news, that's friends, top news people that's out here in New York City and around the world. I do, right? And one thing I find in common when I speak to all of them is that when that's why I didn't want to go sign with ABC News. I could have been with like ABC News on one of these things. You know that, right? I was introduced to the person that runs and owns ABC News. I was introduced to them while I was at Diddy trials, bro. I could have been doing that if I wanted to right now. But one thing that was a common thread between everybody that worked with the news that spoke to me is they said that, yo, we are limited. Even on their social media channels, their pages, Instagram, whatever, they can't post what they just want to post. They can't say what they want to say. They got to do news-based related stuff. They can't just talk about whatever. You go to a quinceañera, your niece quinceañera, you can't even talk about that, bro. You can't talk about regular things that you want to talk about. You're so limited. One guy, and I seen him again when I was covering the Taylor Swift wedding, he was like, yo, man, Uda, I was listening to you. I got 8. He works for the news, bro. He didn't even have no subs. He's like, yo, Uda, I've been listening to you, yo. I'm at 18,005 subs now, yo. But I don't be doing no lives. I'm like, yo, just keep doing what you're doing, but start doing some lives. But he was there like, yo, you know these news people is hating on y'all out here? Like me and the Neeks and the people that's covering the trial at the Diddy trial. He's like, yo, you know they hating on y'all. They hating that people are going to y'all for the news and not coming to them for the news. And we're so limited in our voice that we cannot say nothing. We got to color always inside the lines. I could say, you know what? I think they was racist. I could say that. They can't say that. Yeah, I don't like how the judge was in there. He was in there balking. He was in there looking at people crazy. I can say that. He can't say that. He's limited by the contract that they signed. And that's one of the reasons why I ain't signed with ABC. Cool. The index of exhibits. Oh shit, they actually brought up exhibit A in here? Okay, cool then. Okay. All right, cool. Let me see how long this page is. How long the interview is? Jesus Christ. All right, cool. Let's read a little bit of his interview. Judge Roach's interview. I was going to go find it in the other document, but they put it all into this document. Thank you, Jesus. All right, you've seen this, but I could play this audio of this video. I could play this video for y'all if I want to. But yeah, let me just look it up in the background. I play the audio. Hold up. Let me just look it up. Judge Roach interview. Why read it when we could watch it? You know what I'm saying? At least some of it. Let's watch some of this. And then we'll read the next part, okay? Let me just show you some of that. All right, cool. Let's stop the screen share. I'll come back to the document. Okay, cool. This is what they just want to show you what they're talking about. So we don't have to watch it all, but let's just see what they're talking about.
How you spell it?
My name is John Roach, John Roach.
Now, I know the answers to that. I know the answer to that question, but I got to ask it for the record.
100%.
You've been on the bench for some time.
Yep, I've been on the bench for about 20 years.
20 years, and this is the end.
And then 6 months will be in the end.
Did you want to take on this trial?
I wanted the Collin County Judiciary to take on this trial. It was important to me to have somebody from Collin County preside over this Collin County case. So I didn't ask for it. No one, that's not how it works anyway.
Yeah.
I didn't ask for it, but I was certainly willing to do it because that was my duty.
In your conversations with, my guess it's an administrative judge who goes, I know they go down the list and they say, all right, it's your turn and it's your turn. As they go through all the conflicts of judges that may potential conflicts, when they come and say, John, this may be yours, your first reaction is?
I'll take it every time. I think it's my job. It's my duty. That's what I was elected to do.
Yeah.
That's the oath that I took, and I'm going to do my job.
No consultation with your family or?
None.
No.
Nope.
And where does that come from?
I don't know. I think it's just duty. I think duty, whether that's duty in the Marine Corps or just duty to my family and stuff, I take duty really seriously. And I took this job to perform that duty. And if that's what I had to do, that's what I have to do.
Did you fully at the time grasp the enormity of that decision and the outside stuff?
I don't know. I think in some ways I did. I think in other ways I didn't. I certainly knew it was very, very important case within our community. I didn't think I realized the enormity of the social media and the media during the trial.
How long have you been prepping for this trial?
I've been prepping for this trial with the departments, with the Collin County system, with the sheriff's office and everybody for about 8 months.
Is that the longest you've ever had to prep?
100%.
Why?
Logistics. One of the critical pieces of this case where we had minors who were testifying. Prior to me getting the case, we had some of those witnesses doxxed and swatted and revealed on social media. I didn't want that to add to the already traumatic event they've been through. And I didn't want them to change their testimony or be uncooperative with people trying to call them as witness out of fear. And so my number one duty at that point in time getting the case was to how do we protect those minors who are critical to this case to come and testify.
I'm sure you've already read and know that one of your fellow judges has already been doxxed and swatted and all the things.
I did know that.
And still no reluctance from wanting to take it on.
None.
Yeah. The decision to not have cameras or any kind of streaming, was that an easy one?
Yes, it was an easy decision. And I'll tell you why. My primary goal in any case is to make sure that the defendant and the prosecution gets a fair trial, period. I have seen from other cases around the country where cameras in the courtroom changed the way that the judge acted, the lawyers acted, some of the witnesses acted, and we were not going to have that here. We were going to really isolate the purpose for which we were here for, which is to have that fair trial, and cameras in the courtroom did not enter into that equation at all. How
much grief did you get from people around you about that decision?
I don't know. I don't listen to it. I just flat don't listen to what's going on the outside. I do what I think is right, no matter what decision that is. And I sleep well at night knowing if I follow the law, then everything works out like it's supposed to. And so these outside influences, all the noise from the outside, I really isolated myself from that in this case and in all cases, and just do my job, do the best I can, following the law.
How do you think we're talking with the attorneys, other attorneys outside of this. How do you think they describe you?
Strict, no nonsense, fair, and that to me is the most important part. I know for a fact when I make a decision here, people are unhappy. What I hope is when they walk out the door that they think they got a fair trial, or a fair hearing, or fair something. And if they do that, no matter what they think about me personally, then I've succeeded.
And you're okay with any of those characterizations?
I think they're fair.
Yeah. I hate to have to ask about stuff that emerges on social media, but I have to ask it. And I know you don't know of any of it because you're not on social media.
I'm on it. I mean, I'm an elected official, so I have a Facebook page and stuff. Do I look at it? Do I monitor it? Do I let it impact me? None, not at all.
So I have to ask, do you have a personal relationship with the Metcalfs?
I wouldn't know Mr. Metcalf prior to this trial if he walked up to me and said hello. I don't know the Metcalfs. I sympathize with the Metcalfs and what they've been through and all, but I don't know them personally. Never have.
So these AI images emerging of you and them at a party or drinking together, all
Never
of
happened.
that.
And that's the problem with social media, isn't it? You can't tell what's true and what's not true.
He messed up right there. That's where he messed up. That's one of the spaces where he messed up. He messed up multiple times. But listen, the court themselves, the defense and these people not charging with it. They didn't bring this up. This is something that's on social media. He's supposed to decline to answer that from the interview and say, you know what, I decline to answer that. That's social media, man. You know what I mean? That's nothing that's really written in stone. You know what I'm saying? And come up with a kind of a slick way to kind of get around that question instead of answering that said question. That question also tied him up and is also giving the grounds for him to recuse himself. As far as Karmelo having the whole new trial, that's something else. It could be going towards it, but that is just good grounds for his recusal, not for him to win the new trial or him to get the new trial. For this guy to get up out of here straight. Because remember, when you put a motion for a new trial and all those things, right, he's going to be the person that's presiding over the evidentiary hearing. but they're not asking for him. They're asking for Ray Willis, Honorable Ray Willis, or Willis, whatever his name is, because he's the one that actually picks judges. When after judges get recused, he picks judges to fill the void, to be interim judges. And they're not asking for an interim judge. They're asking for the top judge to be the interim judge. In this case, hoping that he could get some real fairness in this evidentiary hearing and the grounds for the new trial. So I think that they got some good grounds on that, though. Let's listen to a little bit more of this. I'll look at some other documents as well and break down a couple of the charts that I have as well, so we could get into some of that as well. All right. Salute to everybody. Make sure you got the likes on go, shares on go. After this is done, hype it, all of those things. All right. Make sure you subscribe and hit the notification bell.
I will tell you, I got some reports of some things that were coming out of this courtroom, and I wondered to myself, were they even in the same courtroom that I was? It's that bad. And I think that's tragic, because I think really if you just listen to the case based upon the facts, you'd understand it so much better.
Do you think it reinforced your decision to not have cameras or streaming inside this?
Sort of. I will tell you this. Sometimes I think maybe I should have at least the audio streamed or something so people could hear it. But at the end of the day, I don't think, no matter what, people are going to distort whatever happens or whatever they hear into their own agenda. And so what's the point? And again, that noise affects people. It affects the fairness of the trial, the safety of the witnesses, the safety of the jury. And those are my primary concerns, not what social media says. It's not my duty. I don't think it's my job to feed social media or the media stuff. I certainly understand the role that media plays in a case like this, but I'm not here to feed it. And I took that very, very seriously.
But Judge, when people don't have access.
You just fed it, sir. By answering the damn question, you just fed into it. Not only that, you became impartial. I'm sorry, you showed your partiality. Actually, you wasn't even impartial. My bad. Because you said, you know what, I side with the Metcalfs. We know we're human beings, though. He's a human like we're human beings. So you could side with it. You know what I'm saying? Like, I feel sympathy for the family that they lost their son. You know what I mean? I even feel some sympathy for them. It doesn't matter, bro. You know what I'm saying? Because a person's racist, that don't mean I have to be racist. I don't care about that, bro. So I'm saying I'd rather get up on your damn heels, get you up. You know what I mean? I don't got to be racist to you, bro. You know what I'm saying, sir? It is what it is. I get my lick back. You know what I'm saying? It is what it is. But he stepped outside that line. And then he also said Karmelo committed a crime. So you speaking, this shows that you're leaning more towards one side. And I think he played himself with that, man.
To the trial or the courtroom, doesn't it invite speculation?
Well, sort of, but I got 70 seats in my courtroom, and I had 200 requests by the media to sit in the courtroom. So let's say if I just entertain the press, then I have nobody from the public watching what's going on in their county. And so I had to do a balance between the media's right to know and to be able to report what's going on, because I think that's extraordinarily important. I think it's important that the general public had access to the courtroom and to see what was going on. And so I tried to balance all those things with the primary, again, purpose of having a fair trial. And I think I struck that balance pretty well.
But the media's right to know is the public's right to know. Is the public's access. We are the extension of that public.
I think somebody from the public who will wanted to come watch a trial and know that they were excluded from a trial because all the media was there, I beg to differ.
He look at the little cynical, the little that thing, bro. It's a public trial, bro. That's why everybody have a right to a public trial. Okay, he kicked the public out the trial. It is the taxpayer's right to be a part of a public trial. It's our right. Why do you think they even created these laws and put these things in the Constitution? Why do you think they put this here? Because people were getting railroaded. That's why. You know, law used to be different, right? The king used to decide everything. Bang, you done. The king, behead him. It was the king doing everything. We're like, nah. The king wilding, bro. Listen, we gonna get the jury going. Boo, 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 boo. This is why all these things started to take place, bro. It's because everything was under the king. Remember, we was gotten by Britain. Everything came from Britain. They whole systems is what came and created this system. Rome helped create theirs. Theirs helped created this, and that's just how it works. Bomb, 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 through history and earth. Okay, and it was about the queen, about the king, bro. But remember, the king could be unbiased. I mean, the king could be biased. He'd be like, you know what? I don't like him. The way you look at him, behead him. That's why we have these things set in place. So when the public come in the courtroom, right, we're there as witnesses to the trial. We're there to watch the jury and make sure they're being honest. We're there to watch the judge, make sure he being honest. We're there to watch everybody in there to make sure that everything is being honest. That's why we're there as the public. And it's our tax-paying right to be there. We fund all these things. Our taxes who pay everybody, police, these people, everybody's salaries get paid by the taxes of the people. Rome created that system, sir. Not Britain. Rome created that system. So you got to understand that we, the people, matter. Why you think it's not we, the people? We, the people, do matter. But our issue is that we always arguing about each other, going to color and all this other stupid stuff. That's how come we can never make a change nowhere. Because for us to make real change, it's going to take more different people. Let's think slavery for a change, right? You think it's all black people that changed slavery? No, but people want to be racist today. It's just stupid. Bro, listen, you had abolitionists, you had white people that was helping. We're talking about Underground Railroad was a chain of other people, places, white people, basements, all types of stuff where people was being hidden at. It took black and white people. It took multiple races together to help to make that change, to push aside slavery, bro. It didn't just take black people revolting and everybody running like Nat Turner and everybody pulling a Harriet Tubman. It took more than that to change the landscape of slavery, bro. Do you understand that? So to be racist today is crazy. And I think racism is a learned thing. They say it's a taught behavior. But you can't go through a situation that can make me turn you that way sometimes. You know what I mean? You go through something with somebody, now you're looking at everybody one way. I get it. But at the end of the day, to make real change and not incremental change, not just a little small change, we got to understand that a lot of us are the same. Even though we ain't different colors, we different regions, different religions, denominations, all of those things, right? But it's about the haves and the have-nots. It's about the people that's the big people on the top that want to keep the low people on the low. That's what it's all about. You feel me? And when laws are passed, what you think they're affecting? They're affecting us. They're affecting me. They're affecting you, the white person. They're affecting the Spanish person, Latino, Latina. They're affecting the Asian person. They're affecting the Indian person. They're affecting all of us. All of the laws, all of these things and these changes is hurting us all. While we focused on watching TV, while we focused on arguing with each other, this is how everything gets to pass. And then, you know what? It's our ass in the end. Straight. So we got to be smart. Got to start working together. Got to start working together, bro. I'm telling you for real, man. It's not a joke. Karmelo was in a bad one.
You don't know what it is down here when you're guilty from the moment you're born. And you can buddy up with these white folks and make them laugh and try to make them like you, whatever that is, and you say yes sir, no ma'am, but when it's your turn, they ain't got to have no fingerprints, no evidence.
I think there was a possibility for a learning experience. I mean, people do not know about how trial works. Do you think that this may have been an opportunity for people to know how it truly works, and that kind of erases some of the negative notions of court and trial?
I'm doing
and
this
justice.
interview with you to make sure that people understand how the system works. And if they really wanted to, and I mean this seriously, if they wanted to, they could have stood in line with everybody else and had the 27 to 32 public seats that we had in this courtroom that we rotated every day. And so was that important to them? They could have made it in here.
How did you plan for some of the outside?
Yeah, that's weird as hell, bro. So we know it didn't go down like that. And reported in the documentation. I'll bring up the documents right now. Anyway, hold up. We can pull into the gag order, all of that stuff as well. Let me see. Do you want to read the gag order, see what's going on with the gag orders? We can read the gag order, but look, let me show you this. He's saying it's so easy, easy peasy, easy breezy, cover girl. He think this shit cover girl. No, it's not, bro. It was difficult as hell to get up in that building, bro. He's just gonna say that. Hold up, let me find one of these things for these people. Hold up. Any one of these exhibits. Let me find an exhibit for y'all. Okay, declaration of her. Anybody? Oh, but was she the one? Submit away. All right, cool. Let's just go into this real quick. Let me show you. Show you better than I could tell you. All right, cool. Let's go ahead. And let's read some of these things right here, like these, right? Boom. Make it a little bigger. Make sure y'all can see it. Y'all can see it, right? Cool. So now look, let me just read this to y'all real quick. Let me put my mic on so you can get closer to me so I can hear me better, right? So look, this is of Tamitra, right? Tamitra Carter, if I'm not mistaken. Yeah, Tamitra Carter, right? My name is Tamitra Carter, and I am over the age of 18 of sound mind and fully competent to make this declaration. I have personal knowledge of the facts stated below in each of which is true and correct. I am a member of the public. I had no role in the case. I sought to observe the trial proceedings in this matter, which were substantial public interest. The statements below are based on that. The proceedings that I sought to attend. I went to Collin County Courthouse on June 4th and the 5th and the 6th in an effort to observe the trial proceedings. On June 4th, 2026, I arrived approximately like 6 a.m. There was already a line of members of the public waiting to enter the court. Because of the limited number of public seats available, I was unable to obtain a seat in that courtroom. He's just saying you're just gonna have to come out there, bro. People that was lined in the line, 7th in the line, ended up multiple times being like 30 something in the line. People coming through, skipping people, all kind of things are happening, bro. It's a trial. Everybody's trying to get in here. Okay, people lying to security guards, to officers that's there, lying to officers saying, yo, listen, I'm supposed to be in there. Da, 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 da. They lying on other people just to get in there. It's a lot of shady business going on in there. A lot of shady business. Okay, on June 5th, 2026, I arrived approximately like 4:30. So now she bounced back on her King Bond. She came back earlier, right? 4:30 a.m. And it was among the first members of the public to arrive. When I arrived, I was informed that I could not remain at the courthouse because it was not open to approximately 6 a.m. So she got there at 4:30 and it was like, nah, you got to get up out of here, man. Because, you know, you could have got contempt of court and all kind of stuff. They could have been physically removed you. This is in the order. You could have been physically removed, banned from the grounds, and you could have been held in contempt of court. They'd have locked your ass up and you'd have to pay a fine. You know what I'm saying to you? Just for coming out there a certain time. Just for being on the grass. Just for being over there. It's called the pre-dawn line. It would not be open till approximately 6 a.m. So she came at 6 a.m., wasn't able to make it. So the following day, she said, you know what, let me come at 4:30. Maybe I could get up in the building. You know what I'm saying? I want to see what the hell's going on. I don't want to be standing outside with everybody. Comes at 4:30. They tell her, nah, man, you got to get approximately at 6 a.m. Members of the public were directed to wait at a nearby church in a racist town where it's damn near 70, 80% white. No slack to my white brothers and sisters, but it's 80%. You know what I mean? Pearly. Real. And it's early. Pearly and early don't go together too good. You know that, right? See a pickup truck ride by you. With a, you know what I mean? With a toothpick or something. You won't see that. Anyway, she said at 6 a.m. she was not supposed to go to church. Before leaving the courthouse area, a member of the media recorded my initials and advised me that I was number 7 on the personal list that he was maintaining of the early arrival. So listen what happened. Before leaving the courthouse area, though, somebody was there. A member of the media was there. Remember, they was there. Media could do different things probably, right? So the member of the media recorded my initials, TC, Tamitra Carter, and advised me that I was number 7. That's how early she got there, that she was 7th on the list. And he was maintaining the early arrival just to show, like, look, I've been here since early. These were the first people. So people was out there just doing this on their own. Look, man, I got a list, man. This is who early here. This person didn't have to do that. This person was a part of the media. They didn't have to do that, right? But this is maintaining some sort of order that showed you that people doing this like a Samaritan type of a work. At approximately 5:30 a.m., members of the public returned to the courthouse. I was the first vehicle waiting to enter the parking lot, and additional vehicles were lined up behind me. Before 6 a.m., the sheriff deputies temporarily moved away from the entrance after hearing the vehicles behind me honk. I believed that we were being allowed to enter and slowly pulled forward. When I saw the deputies returning, I immediately stopped because I did not want to enter before I was authorized to do so. After I stopped, 2 vehicles behind me were involved in a traffic collision near the entrance of the courthouse parking lot. The law enforcement responded to the collision, and afterward, we were instructed to proceed into the parking lot. After the parking, I attempted to approach the courthouse, but was instructed to return to a stop sign and line up there. By the time I reached that location, approximately 20 more people were already standing ahead of me. Even though I had arrived among the first members of the public that morning, I ultimately found myself approximately 35th in the line. So when I'm telling you these numbers, 35th, somebody end up 30 something in the line. I'm telling you the truth because I'm reading the document. I'm not just telling you things I'm thinking in my head. And Team Purple, we Karmelo. No, I'm just telling you real stuff because I'm reading the documents. I have all the documentation, real talk, in contact, call it, I mean, legal teams, all types of shit. Buddha is behind the scenes with this, but I'm into getting the facts, right? I explained to one of the sheriff deputies that I had arrived early and did not understand how I lost my place in the line. I asked whether the line could be organized according to the order in which people had arrived, but my concerns were not addressed. I then spoke with the same media representative who had recorded my initials earlier that morning. He confirmed that I was number 7 on that list that he created. He attempted to explain this to the lead sheriff deputy, whom I believe was named Brasco. Brasco. Heard about him. Heard about. Some people said they liked him. Other people said that he was a. I ain't gonna try to call nobody no names. You know what I'm saying? I ain't gonna call nobody no names. But he was moving like Donnie Brasco, if you ask me. I'm just gonna leave it there, y'all. Leave it be. Leave it be. The deputy did not recognize the list and directed that I be removed from the line after believing that I had skipped ahead. Ooh. So she went to a space saying, like, no, look, the media guy's here. I've been here since 7. This is a credentialed press. Look, he's telling you the truth. I've been here. He's documented who came here first. So she probably seen a line of 20. It's like, nah, I was 7th, bro. And trying to get back to her 7th position, speaking to the deputy and all of that, bring the media guy too to confirm it and show that she's not doing nothing untoward. She's doing something really, really factual here. She was removed because she had skipped the line. Because only approximately 27 seats were available to the members of the public, after being removed from the line, it prevented me from observing the morning proceedings on June 5th in 2026, the events of June 6, 2026. On June 6, 2026, I arrived approximately at 3 a.m. So the judge talking about, you could, if you really wanted to be in that court, you should have just came out there. You should have just stood your ass on this racist county in this line where everybody just skipping the lines and doing anything they want to do. And you done put all the weight on some public officer to make this rules like he's somebody special, like he can't be biased. Because I even heard this guy, Brasco, was mad biased. Allegedly. I'm telling you, bro, I heard that too. The man was biased. You want me to do an interview with somebody that say he was biased? The man was biased. That's what I heard, bro. And the person never lied to me. So I ain't got to. What the person lying to me about him for? I ain't even go to the trial. I was supposed to go. So what you lying to me about Brasco for? The hell that's going to do for my day? And that's the price of tea in China? That don't have nothing to do with it. You see what I'm saying? So listen to me. She arrived, Tamitra Carter, arrived at 3 a.m. because there was no official numbering system maintained by the court. Members of the public created and maintained our own numbering system while waiting in line in an effort to preserve the order in which people had arrived. So people started coming up with their own system. Like, about that. Yo, bro, I'm like, yo, when you third, listen, I'm telling you, your media guy, yo, stamp this. Yo, she 3rd, I'm 4th. Look, what number are you? I'm 5th. All right, cool. Look, boom, boom, boom. Now people doing their own thing just to show. Now we 5 deep, 10 deep now. Now we on Brasco Kofi. Now Brasco, look, she 5th. I'm the media. Look, we all confirming this. I go talk to another officer. Yo, I'm 7th in this line, man. I remember I told you I'm 7th. All right, cool. That's it. So when Brasco come around, I'm calling you. You tell Brasco, since y'all go to lunch together and y'all, since y'all that. Anyway, look. So they came up with their own number system. To the best of my knowledge, I still possess a photograph documenting the public numbering system that was used that morning. Members of the public were instructed to walk, not run, when approaching the courthouse. On June 6th, I was admitted to the courtroom. She was admitted this day because they came up with their own system. You know what I'm saying? And she came at 3 o'clock that morning. That's crazy, bro. You can't get no sleep, bro. You think she got sleep that day? I was admitted to the courtroom and was able to observe the proceedings that day. So based on my personal observation, there was no official system in place to preserve the order in which members of the public arrived at the courthouse on June 5th. As a result, despite arriving among the first members of the public and being identified as number 7 by the media representatives list, that's the media's representatives list, which is a credentialed press, I lost my place in the line and was able to unobserve the morning proceedings. On June 6th, members of the public created their own and maintained our own number system while waiting on the line because no official numbering system had been established, and she got up in that building. Okay? So when the judge is over here talking about all you had to do was just wait up in that line and you would have get up in there and don't pay no mind and all this other dying and all this other stuff, you know, like from Texas. When he talking all of that, it ain't really true, bro. It ain't really true. You know what I mean? So it's nasty work with that one. So the judge was lying.
You lying ass bitch.
I ain't call you no names, Judge. So to run down an Uda, I ain't call you no name. Cat Williams called your ass a name. I ain't call you no name, so don't judge me, brother. Yeah, though. So it's nasty work, though. Most definitely is nasty work. Mike Howard, it was shady business with you, sir. Most definitely was shady business with you. You know, you went into that handshake deal with the prosecution, which was crazy. Most definitely went into that. Tied Karmelo's hands, basically. That's why he couldn't really say nothing, really do much, because you tied his hands. He didn't even testify in his own trial after Yah was supposed to call him as the last witness to be called. Couldn't call no evidence, couldn't call no experts, couldn't call no character witnesses. They was gonna call a neuropsychologist to talk to his mind, talk about his epilepsy, all these different things. Neuropsychologists talk about him being 17 years old, the fight or flight responses, all of these different things, maybe him being scared at the time, who knows. Couldn't do any of those things. The defense wanted to call a coach. This is how binding that they were binded into this agreement, which was not on the record for real, right? They tried to call a coach. They said, what you calling this coach for? That don't bring up his character. What you mean? He said, Mike Howard told Bill Werski, the prosecutor, that, listen, I'm calling the coach because the coach witnessed Karmelo's seizures and stuff. So I want him to come and testify to that. You know what I mean? Bill Werski was on his bumper body. Listen, man, you finna open the door. It's going to be an open door. Then after you open the door, I'm going into cell phone records. I'm going into this. I'm going into background. I'm going into school records. I'm going into disciplinary records and all of that. Every time, threatens. He ended up not even calling the coach. So when we're wondering, why wasn't character witnesses called? Why wasn't certain evidence called? Why wasn't no pushback on the students? Why not? Why? Why didn't Karmelo testify in his own self-defense trial when you know that you're supposed to testify in your self-defense trial? If you claim it's self-defense, okay, even a layman lawyer knows your client must testify. You got to go up there and turn the water. You ever play Monopoly? Waterworks, utility, electricity with the waterworks. Forget about Bar Park Place. Forget about Bulwark. Forget about St. Charles Place and all that. Waterworks coming down the face. Yeah. Electricity, the feeling in that building, the utilities from the Monopoly board is working. And that's how you're going to get a chance. That's how you play Monopoly in court, homie. Trying to show you something. You know, trying to put you on game here. But it was nasty work, man. Karmelo had to talk to his lawyer like this. Like this dude done ran down on Matthew McConaughey, Samuel Jackson.
He's a witness for the prosecution. You my lawyer, ain't you? Yeah. Ask him.
Your Honor, one question.
Make up your mind, Mr. Brigant.
But we know that he didn't want to ask the judge and nobody no questions because he is the one who entered into a shaky deal with the prosecution, Mike Howard. And he was supposed to be a good lawyer. I heard from even lawyers that actually do cases in Collin County as well. Okay, I know one person specifically that actually has done a couple of cases in Collin County court and has been in Judge Roach's court himself and kind of talked to me about Judge Roach. He said he's kind of a fair guy, supposedly, but that guy's from Texas as well. So, you know what I mean? He could be binded by some of the things he might say. He might come and say something, and then that might be used against him. You know what I mean? So imagine if you was a lawyer that's practicing out of Texas and you've been in Collin County, may still have a case there. So in Collin County, under these people, you know these people as well. You know what I mean? You'd be less likely to really want to say, nah, son, I think they disgraces. You know what I mean? You'd be less likely to say that because you're down there and you don't really want to fall back from that type of stuff or that type of a comment. You know what I mean? But he was saying it was kind of basically kind of, you know what I mean? He said he didn't see no unfairness, man, and that's probably based on who he is and the relations and the connections that he has. But he didn't speak on nobody else seeing no racisms. So that's something that you should think about, right? Okay, again, the Waller factors, which I broke down for y'all, okay? These are 4 of the Waller factors that they feel that the judge has broken or breached, or whatever the case. An overriding interest of closing the courts and the observation rooms and the overflow rooms and the live audios and the video feeds. The court must find an overriding interest that is likely to be prejudiced. Okay, 2, narrowly tailored. The closure must be no broader than the necessary to protect that interest. 3, the court must consider reasonable alternative to the closure of the courtroom. And 4, for a fact he broke this. He done went on the damn news. He done went and wrote a letter speaking on this 4th one, which played himself all over again, the Judge Roach. In adequate findings, the court must make findings adequate to support the closure on the record. He never did nothing on the record that supported this closure, okay? And this is some of the reasons that they are justifying that Karmelo is going to get a new trial. 1, no court feed. The live video feed of the courtroom was cut without adequate justification, preventing the public from observing the trial. This is only after they allowed the overflow room and the public to observe the trial from the jury selection process from voir dire. Then after the voir dire, when it came to the testimonial phase, when the prosecution and the defense is going up to do their case, they pulled the overflow rooms, pulled live feeds, audio feeds, live streams, and everything else from the case abruptly with no just cause or no reasonings at all on the record. Yes? Cool. No overflow rooms. No overflow rooms were provided for the public, and you're supposed to make alternatives. If you don't make an overflow room, you're supposed to be able to come up with an alternative. No alternative was sought, okay? So no overflow rooms were provided for the public who could not fit in the courtroom, denying access to those who had the right to be present. As the public, you have the right to be present in public trials. Our tax-paying dollars is who pays their salaries and who pays for that court. You paid for the court building. You helped build that building. That's what our dollars do. But we so busy arguing with each other instead of pooling our minds together, pooling our resources together, and pooling our dollars together. And I bet you we start to make some changes in America. In America, if you slow, right? Cool. No audio feeds. No audio feeds were made available to the public, further limiting the public's ability to follow the proceedings, which left and allowed all of the misinformation that we've been seeing, all of the things we run around on TikTok. I even got some stuff where I'm about to get in and kicking some Karmelo Anthony supporters' asses because they don't want to talk about, no, we seen the real video and he was getting jumped and all that. Ain't no real video. That's the only videos that anybody saw, bro. So what video they said? That man that went up there, the next man that went up there, and the woman that went up there and was talking in front of like that little press conference outside. Remember they had a little conference? Was all liars. And we're going to get into your ass too, son, because what you got to lie. You ain't got to lie to kick it, bro. Look at how many more things is coming about the twins. They doing racist graffiti. They had some racisms in their background. They was bullies. Other kids said, yo, the same thing that happened to Karmelo, they done did to us, bro. Same thing happened to Karmelo, they done did to us. All of these things are coming out, and what ain't coming out in the wash, coming out in the rinse. So why you got to come up here before and try to lie just to push a narrative, bro? Talking about y'all seen a big video clearly. They said they seen a 4K video clear, and you could see him being surrounded. You could see the people fighting him. Remember those people was outside the press conference, outside the courtroom talking? Just lying, bro, for no reason, bro. You don't got to lie to kick it. I think Tupac said that shit in like 9 something. You don't got to lie to kick it, bro. It's crazy, bro. Y'all further disturbing the whole thing with that dumb stuff, bro. It don't even make sense. No live streams. No live streams or remote access was provided to allow the public to watch the trial in real time. Exclusion of the family and the public. The family is going to be one of the reasons that gets them kind of binded up and caught up, because each side, Karmelo and the Metcalf side, were allotted 15 seats each, but Karmelo was only limited to 8 seats. Even his own grandfather and aunt were not able to make it to the trial at all. Do you hear what I'm saying to you, bro? That's shady business. One case, Stricker case, in the Stricker verse, whatever case, one family member wasn't allowed to be a part of the jury selection process. New trial. New trial. Do you hear what I'm saying to you? New trial. Karmelo family members, grandfather and all, didn't make it. This is grounds for the new trial. So they have compounding reasons, not just one. So everybody's saying, that ain't enough, just some handshake deal. Slow down and read all the documents. All of the things compounded on top gives it good grounds. Will it go through? It's hard to get appeals, but they got a good shot. That's just in my perspective. They have a good shot. You know what I'm saying? This period. You know what I mean? Okay. The family members and other members of the public were not allowed in the courtroom, violating the right to public access, and no adequate justification. This is the last one. That court, Judge Roach. The court failed to provide adequate findings or reasons for restricting access and removing the public from the trial. Okay, we went into the Waller factors already, right? I told you that. And now this is the last one, just quick, fast on the way out. These three cases up top are where they're kind of citing to show how the judge broke this whole thing down, right? Waller versus Georgia, no overflow room. So the no means to the overflow room and the live or remote feed available, okay? The entire suppression hearing was closed. No alternative was offered. You have to offer an alternative. What was the outcome of that case? A closure was unjustified, and a new suppression hearing was ordered. In the Stedman versus the state case, no overflow rooms. The family was barred from voir dire, which is the jury selection process, for lack of room, and no alternatives were considered, not even for the family members. A structural error, conviction was reversed, and a new trial was ordered. In Lilly versus the state, no overflow room. Trial conducted in a restricted access setting. What was the outcome? Structural error, new trial ordered. In the Presley versus Georgia, no observation room, reserve rows, and overflow not even considered in that case. It was reversed. The trial court must consider reasonable alternatives, okay? In the William versus State, yes, they had an overflow room. Yes, they had a live feed, and it was a trivial closure. It was like, maybe it's a little bit, but there was no violation, though. You're like, maybe it could have been a closure. It could be something, but it wasn't that much, okay? In Zorns versus Bolin, yes, it was overflow room, remote viewing from an observation room, right? A live feed, live stream. There was a trivial closure, but no violation. In Karmelo's case, in this case right here, let me take off this banner. In this case, they provided a observation. They provided an overflow. They provided an overflow room in the beginning in the jury selection process, then pulled it right before the testimonial phases, then withdrawn it for the testimony. No feed thereafter, didn't think of no alternatives. So this case falls on the Waller, the first one, Stedman, the second one, and the Lilly side of the fence on all three of these. And in all three of these, new trial ordered, suppression hearing ordered. Okay. So everyone had a new trial ordered in all of those situations. So based on those things, I think that he has a good chance, man. Yeah, man, they have a good chance, man. But I've been working on the railroad in McKinney, Texas. My Sherry more. Hold up. Stevie Wonder could see this railroad more and more. Even Stevie could see this damn railroad, bro. Even Stevie. He ain't got the wonder. Because Stevie don't got to wonder if this was a railroad. That's facts. That's facts. I'm entitled to my own opinion. It's America. You can have your own opinion. This is on go. Say what you want to say. I never said, go on and get, because you're talking about this and that. I ain't never told you that. Some people come joking on me. I ain't never block them. It's not that serious. I joke on your ass right back. I'm funny. I'm a funny guy. I don't care, bro. I'm not in my feet. You don't see me in my feelings. You the one that need a damn hug.
Excuse me. Buying hugs for $1. No. I'm buying hugs. I appreciate it. I want to give you $1 for a hug.
I appreciate it. We got the close physical contact.
None?
Exactly. No close physical contact right now. Pause. Yeah. But yeah, man, everybody make sure you're on go. Make sure you're subscribing to the channel. Hit the notification bells. Hype this video afterwards if you can, after the video ends. Go into my comment section. If you're still here with me after this video ends, go into the comment section and just write a comment. Put something in there. Put an emoji. Do something. These little things help the videos to move. Go back in my videos that I've uploaded. Drop likes on stuff, even if you don't get to watch everything. My live videos, go back in there. Drop likes, man. Just go around dropping likes on stuff. Put comments on things. This is how we help each other. Everything is not about $1. You don't see me begging for $1. I'll tell you, open up your purse strings. I ain't tell you all day, right? I've been reading. Half these motherfuckers online can't even read. And I learned reading rainbow. I can read anything. Exactly. Taught myself to read. And I'm here reading, That's how come sometimes I'm not involved with the chat, because when I'm on the other page, I can't see this whole screen. I can't even see this screen. And I like to just read for y'all and just give y'all the information, try to give y'all a little entertainment too as well. My entertainment is not meant to take away from the seriousness of any situation that I cover. I was out there talking about the Diddy chop, squirting nose on motherfuckers, whatever it is going to be, what it's going to be. I don't give a fuck. It is what it be, what it is be. Because we need to laugh through shit too, man. Shit be so stressful, so many things stressful in our own lives that, yo, if you don't smile, it's like you just perish, bro. If you're not able to laugh, bro, it's like you just gonna die, bro. It's just serious business, bro. So we gotta maintain that, man, even in some of the most harshest situations, the most tragic situations. So that's what I do. I just try to make a person laugh and feel good. You know what I'm saying? Even though sometimes we in the darkest days, or sometimes we covering some dark situations and stuff like that. When it comes to certain things, I won't try to laugh about that because it's real serious. You know what I mean? But if I could bring some kind of light to your life, you know what I mean, I try to just bring that across to you. So, you know what I mean? That's all it is. So don't take it personal with me. You know what I mean? So it is what it is. But this was a damn railroad. And Judge Roach, they on your ass.
Shit. Got your ass.
Yeah, they on your ass. You know what I mean? Brielle, they on their ass. Shout out laughing. Wise eye salute. You know how we do, bro. You know how we do, man. I just be trying to bring the entertainment side. You know what I mean? They're like, oh, you was out there all the people up. Yeah, nigga, so what? So what, nigga, about it? Chill, son. I still slap your girl. Don't even play around with me. I'm the guy. I'm that one guy. What the hell are you talking about? Shut up. Stupid. They dumb, son. Nobody questions my sexuality. Don't be stupid. No one. Ask anybody else at that trial what they think about me. Ask them, was I not defending them outside that trial? Ask Neek. Ask any of them people out there, bro. Men and women. Go ask Mel watching the world something. Go ask anybody. Well, who was Uda for you, bro? Was people bothering you out there? Was people saying things? What people talking and stuff like that? What was Uda like? Was Uda getting on people's heels for y'all? Not me. I don't got no problem. I'm out here with the blick, the stick, and I'm out here with the brass nicks. I had all three of me every day. I told you I'm gonna have my three confrontational items. My non-confrontational one was the breaker jaw. I had my yoker, and I had my stroker. Sorry, bro. I got beef in New York City. What the hell I'm supposed to be running around here chilling in a crowd of 1 million people? What the hell I look like? Trump? Don't be dumb, stupid. I'm here to live, not here to give. Anyway, but yo, this is a fact, bro. I protected my life every day. Till my homegirl Candy, remember Candy, MTA lady, stole my brass knuckles, nigga. I said, yo, hold these for me. I'm going in the court, yo. Stole my shits, bro. Ask him. Uda, it's in my house. I'm going to go look for them. 1 day passed. It's still in my house. Uda, I'm going to find them. 2 days passed. It's still in my... Yo, Candy, stop playing at me, my game. Yo, MTA lady, where the hell my damn brass knuckles is at? Don't play at me, bro, if I get up in your ass. You know what I mean? Not the way she wanted me to, because she really wanted me to all her up. And I ain't want to all her up. You know what I'm saying? I'm like, chill, Candy. We friends, man. You got to be friends first. We friends, Candy. Ask MTA lady if you see her. Ask her, yo, did you get Uda brass knuckles? Yeah, I had Uda brass knuckles. I couldn't find them. Lying ass. No, she probably done so much. You done gave my shit away to a nigga probably. That's that type of nice. She even sell my shit. She probably just gave my shit away. You know what I'm saying? Like, oh, you want something? She just wild. You know what I'm saying? After I told her to hold my shit's for me, bro. You know what I'm saying? How I'm supposed to be protecting us out here? Ask Cassie Mons, Regina Ventura if I ain't come and protect her. Ask Justin Mons if I ain't come and protect her. Ask Mama Combs if I ain't come and protect her. Ask my sisters that was outside that trial. Ask Dollar Mouse from the news when that white boy John was trying to act up. I ain't go press John about it. I said, yo, how you make a dollar feel like that, bro? Don't be having a feeling crazy, bro. What's wrong with you, bro? What's wrong with you? Don't do that. You know how many people I was out there on the protection table? Come on, bro. Who protect me but God and Jesus? That's it. Y'all be forgetting about a person like Uda. Y'all be forgetting about me, bro. But it's all right. Y'all can forget. It's all right. I'm don't do things for a reason for nobody to say thank you. But whoever could forget me, God never forgot me. He doesn't forget me. And Jesus don't forget me and never forgot me. And that's the reason. And that's what I do it for, man. And I see so much other blessings come in my life, to me, to my children, and to people around me, man. And that's what I'm so blessed for. So to me, it ain't about a person saying thank you. It ain't about, you know what I mean, a person giving me something, some monetary thing or something. You know what I mean? I don't ever ask out for money. You know what I'm saying? So I just do it for the love, man. I really just do it for the love, man. So just know that, man. Subscribe to the channel. Uda, Uda, Uda. You know we on go, man. On go. On Jesus Sandals, man. You know the vibe, man. Salute to y'all, man. I love y'all all, man. I'll be back in a minute. I'm gonna do another live.
All my niggas been All my niggas turn shooters. All my ops turn racks. All my niggas